Thank you for taking the time to join us today for our 2024 Labor and Employment Fall Update. We have some really interesting and informative presentations today, and we hope that you enjoy them. If during the presentations you have any questions, you can submit them through the Q&A box in WebEx, and we'll have a chance to answer those at the end of today's program. If we don't get to your question, or if you have a light bulb moment later on, don't hesitate to reach out to any of us. We're always happy to nerd out about all things labor and employment law. And without further ado, I'll turn it over to Jen Seal for our first topic today, with a title that I think we can all relate to.
Thanks, Jonathan, and hello to everyone participating. As Jonathan said, my name's Jennifer, and I'm an associate in the Labor and Employment Group based in Toronto. So they're seeking damages for what? It is the age-old question of how much will you have to pay for a wrongful dismissal, and hopefully I'll provide some insight on aggravated damages today. So if you just go to the next slide. Today I'll be taking you through a recent Court of Appeal decision called Krumpotek, sorry if my pronunciation's wrong on the name, versus Thunder Bay Electronics Limited, and the decision's impact on how courts in Ontario may award aggravated damages moving forward. I'll take you through the facts, the procedural history in the dispute, and the Court of Appeal's decision, and then briefly discuss the importance of the case. So first, the facts. Drago Krumpotek was employed by Thunder Bay Electronics Limited and Hill Street Financial Services for nearly 30 years before his employment was terminated without cause and without notice. At the time of termination, he was working as a carpenter, was 59 years old, and earning a salary around $72,000 per year. His employment was terminated within 2 hours of him returning to work after recovering from a back surgery that he required due to multiple workplace injuries. Thunder Bay Electronics offered him a severance package of 16 months salary, which was rejected, and he commenced an action claiming wrongful dismissal, mental distress damages, and aggravated moral damages due to the manner in which he was dismissed. At trial, the trial judge made the following findings based on the damages claimed by Mr. Krumpotek. First, the court awarded him a reasonable notice period of 24 months based on his relevant circumstances and his employment and termination. 24 months is the standard limit on the reasonable notice period in Canada, except in exceptional circumstances, for example, extremely long service employees, or employees with extremely specialized sets of skills. So 24 months, fairly standard for someone having 30 years experience at a job. Second, the court dismissed Mr. Krumpotek's claim for damages due to mental distress due to a lack of medical and psychological evidence. The trial judge noted that Mr. Krumpotek, his wife, and son provided evidence of his mental health concerns, but that without further and better medical evidence, such as a medical diagnosis, the judge was unable to conclude those symptoms were not the result of his physical disabilities and inability to work as a carpenter. Lastly, the court awarded $50,000 in aggravated damages due to the employer's conduct in the termination. The trial judge described the conduct as the antithesis of an employer's duty to be candid, reasonable, honest, and forthright, and to refrain from engaging in conduct that is unfair or in bad faith by being untruthful, misleading, or unduly sensitive. Not how we would like terminations to be described. And so the decision was appealed, though, by the employers to the Ontario Court of Appeal, which did decide to rule on it. The employers, referred to as the appellants, appealed the decision on the following grounds. That first, Mr. Krumpotek, the respondent, was unable to mitigate during the reasonable notice period due to his physical incapacity. Second, by awarding Mr. Krumpotek aggravated damages. And third, holding the employer jointly and severally liable I'll only be touching on the first 2 points due to time in this case and for their relevance. So first, I'll just touch on the mitigation piece quickly, as it's a common issue in wrongful dismissal cases in Canada. So in this case, the Court of Appeal upheld the trial judge's decision that Mr. Kompotek's lack of mitigation efforts was reasonable due to his age, the recent back surgery, and his physical limitations to work as a carpenter. The court found that Mr. Kompotek did not require any medical evidence for his physical limitations to prove he could not mitigate his damages. The evidence was relied upon from the respondent, his wife, and his son to establish that he couldn't undertake comparable work. Notably, in this case, there was a surgeon's report related to his back surgery, which was favorable, saying that he could potentially return to routine work in 8 to 9 weeks, but it didn't specifically address his ability to work as a carpenter. So the court found that it was insufficient to prove that he could actually work as a carpenter. Now, second, and most importantly, the aggravated damages in this case. So the Court of Appeal upheld the trial judge's decision to award aggravated damages in the amount of $50,000. As background, aggravated damages are available where an employer's conduct is unfair or amounts to bad faith during the dismissal process by being untruthful, misleading, or unduly sensitive, and the employee suffers damages as a consequence. So the key component in previous decisions is that the employee must suffer damages as a consequence. So long-standing court precedents have held that aggravated and moral damages include compensation for mental distress, but this mental distress must be beyond the normal distress and hurt feelings resulting from dismissal. I want to emphasize mental distress here. So as a quick reminder, Mr. Kompotek had made a separate claim in his action for mental distress damages, but that claim was dismissed by the trial judge due to lack of medical evidence. Regarding the aggravated damages claim in this case, however, the trial judge found that the employers had breached their duty of honest performance by misrepresenting the reason for Mr. Kompotek being terminated. The employers said it was for financial reasons. I don't think they had a great leg to stand on, unfortunately, by firing someone 2 hours after they returned from medical leave for a surgery. And they also didn't provide any documents or financial statements to rely on to prove that it was for financial reasons, which the court said could have helped support their claim. So the employers argued on appeal that the trial judge that after the trial judge dismissed Mr. Kompotek's claim for damages for mental distress due to lack of medical evidence, the trial judge could not then award aggravated damages for mental distress. Seems logical, but the Court of Appeal rejected this argument, noting that it reflects an unduly narrow view of an employer's duty of good faith during the termination process. So the trial judge applied the following analysis, which the Court of Appeal upheld. First, whether the employer's conduct during the course of termination amounted to a breach of their duty to act honestly. And two, if so, whether the employee suffered harm beyond the normal distress and hurt feelings arising from dismissal as a result of that breach. The trial judge found that the employers were dishonest in their reasons for terminating. And then the trial judge accepted Mr. Kompotek's evidence that he was experiencing anxiety, depression, fear, poor sleep, and frustration as a result of his termination. And they relied on the evidence of Mr. Kompotek's wife and son, saying that they witnessed these symptoms. So the takeaways here, though: be careful when terminating an employee. The reasons must be honest and the employer must act in good faith. And where possible, you want to have evidence to support the reason that you're relying on. So if you're saying it's for financial reasons, the financial statements or other documents should be backing that termination up. This decision in particular appears to lower the standard of what's required to prove that aggravated damages are required. The court really focused on the conduct of the employer and then allowed fairly weak evidence or just evidence stated from the employee and their family members regarding the damages actually suffered or the suffering of the employee. So the conduct will be key moving forward. Okay, that's it for me. Thank you.
Thanks, Jen. Next up, we have Aaron Johnson, who's going to take us through some new developments on the human rights front.
Thanks, John. Welcome, everyone. So as mentioned, I'm going to be talking about trends that we've been noticing on familiar human rights issues. And specifically, I'm going to focus on one trend in particular, being neurodiversity. So I'm going to start our discussion with what neurodiversity means and how we've seen it come up in the context of the duty to accommodate, and more specifically, the duty to inquire. I'll then run us through a fact pattern and the issues we've been seeing come up for employers in that context, and then give you guys some practical suggestions on ideally how to mitigate those issues. So understanding neurodiversity. So neurodiversity or neurodivergence is an umbrella term used to describe differences in individuals' cognitive functions, learning and communication styles, sensory processing, and different behaviors, or any combination of those factors. And so there are a number of medical diagnoses for human rights purposes that can fall into the neurodivergent category, including things like ADHD, a variety of anxiety-related disorders, PTSD, or other trauma and stress-related disorders, OCD, autism spectrum, among others. And so a trend we've been seeing is an increase, or really an emergence of, the number of times that the word neurodiversity or variations of that term are being mentioned in the Canadian case law. And so prior to 2022, we've seen there's been about 3 mentions total. And since that year, there have now been 37 mentions to date, with 22 of those coming up in 2024 alone. So early stages, but we're seeing a noticeable uptick. So which takes us to the question of what this means from a human rights perspective. And so the medical diagnoses I mentioned can each constitute a prohibited ground of discrimination, and specifically a mental disability for the purposes of human rights legislation. So as a high-level refresher on the duty to accommodate, as I'm sure many of us are familiar with, where an employee has a disability, mental or physical, an employer has a duty to reasonably accommodate that employee up to the point of undue hardship. And I'm going to focus today specifically on the duty to inquire, which is a narrow exception to the general rule that an employee is required to disclose the existence of a disability in order to trigger the accommodation process. So the duty to inquire provides that if an employer is aware, or reasonably ought to be aware, in other words, if it's reasonably apparent that there may be a relationship between a disability and the employee's behavior or performance, the employer has a duty to inquire into that possible relationship before making an adverse decision, for example, termination. And so this duty can arise, it's very context specific, of course, but a variety of circumstances, such as a sudden unexplained shift in attendance issues or declines in performance, interpersonal conflicts, for example, emotional outbursts, etc. And so given the nature of mental disabilities, next slide there, please, John, it can be very challenging to know whether the duty to inquire has been triggered, and particularly given how sensitive the conversations would be to make such an inquiry, understandably, and of course the fears of stigma that the employee may genuinely have. And so where we've seen employers run into issues with an undisclosed mental disability is generally in the performance management process. And so to illustrate using a hypothetical, consider, say, a high-performing 5-year tenure employee suddenly has a shift. Their performance may be down. They may start showing up to in-person or Teams meetings looking visibly distressed. They're late to work or logging on, and coworkers may be starting to raise concerns that the employee is causing conflicts within the team. So the employee spoke to informally on a couple occasions. The manager wants to keep things respectful, and the employee acknowledges, takes ownership, and says they'll get back on track. And so months go by. Unfortunately, no changes happen. And morale is now down. team performance is suffering. So the performance management process starts, and a performance improvement plan, or PIP, may even be implemented at that time. And so after that process begins, further months go by, and the expectations of the role are clearly not being met. So the employee is either given a final warning to improve, or may have even gotten a sense that a termination may be incoming. And so suddenly, before the termination, the employee submits a doctor's note disclosing a mental disability, requesting accommodation, or may go on disability leave altogether. And so the employer generally has two choices in that situation. Either one, they now go ahead with the termination that is now substantially more risky, given that a human rights complaint will likely follow. Or two, they can start the accommodation process where the relationship is likely deteriorated already and the costs and time invested in the performance management process are now effectively sunk. And importantly, a point I want to make is that the accommodations requested at that stage are likely going to be quite limited. They may either be limited specifically to reducing, say, the performance targets set out in the PIP, or could be a general reduction in hours or days worked, premised on the focus of the employee attempting to maintain their employment. But generally speaking, both parties at this point are not in a great spot. Which brings us to our practical tips on ways to hopefully avoid ending up in this situation. And so while each case, as I mentioned, is highly context specific, and unfortunately no one-time silver bullets exist, employers may consider acting on the duty to inquire earlier in the process, or prior to or at the start of the performance management process. And this starts with keeping an eye out and looking for those shifts in performance or behavior. And so as a reminder, if it's reasonably apparent that a disability may be involved, again, tricky question, but if there's a shift in things that you're familiar with, we may consider having a discussion to see if the employee may be in need of support or accommodation. And of course, that's a highly sensitive discussion. So we want to ensure we approach it with a high degree of discretion. We want to make sure measures are in place to ensure any disclosure of a disability is going to be kept strictly confidential and managed on a strict need to know only basis. But really, we want to frame that discussion as an opportunity to empathize and offer support to build goodwill with the employee. And if in doing so, you mentioned the notes that you've seen in terms of changes in performance or behavior, and offer any support that the employee may need. And you can raise the disability question through reminding the employee simply of whether there is an accommodation policy or respectful workplace policies, and that the employee can reach out to the appropriate contacts to facilitate that process. And they may not feel comfortable responding at that time. So we want to make sure we're following up in writing to account what was discussed, show that the employee is being offered opportunities to request accommodation, all in the premise of getting the story down, building positive facts, creating our photo album of what took place if the matter does escalate. And that can also provide an opportunity to move into termination earlier if it becomes necessary. And above all else, if a disability is disclosed during that process, we want to be collaborative and work with the employee through their physician, ideally, to land on accommodation options that are reasonable to both parties, and hopefully return the employee to the previous performance levels that they had, rather than being forced into the limited options late in the process after the damage has been done. So to wrap up, hopefully I've given some food for thought. If what I've shared sounds familiar to any of you, and with that, I'll hand it back to John. Thank you very much.
Thanks, Aaron. I'll turn it over now to David McDonald, who's going to discuss some new developments and strategic takeaways regarding hiring.
Excellent. Thank you, John. So hello, everyone. My name is Dave McDonald. I'm an associate in the DLA Piper Canada LLP National Labour Employment Group, and I work out of the Calgary, Alberta office. Today, I'll be providing you with an update on hiring practices, as well as providing you some tips on how to avoid common mistakes that are made during the hiring process. Okay, so this is our agenda for today. First, we're going to discuss the pitfalls of an employer rescinding an accepted offer of employment. Next, we're going to jump into the risks associated with an employer providing a two-step offer of employment. And third and lastly, I'll discuss creating an enforceable amendment to an accepted offer of employment. So first, the risks of rescinding an accepted offer of employment. Sometimes after a candidate accepts an offer of employment, an employer may, for whatever reason, not want to move forward with that candidate any longer. When the situation arises, it is crucial for an employer to understand how to terminate the employment relationship in a manner that minimizes the employer's liability. With that in mind, you might be asking yourself, how do I know when an enforceable employment agreement is created? An enforceable employment agreement an employment agreement is not binding on the parties unless the parties satisfy the 5 formal legal requirements of contract formation. But very briefly, first, the parties must have the legal capacity to contract. Second, there must be an offer of employment. Third, there must be acceptance of that offer of employment. Fourth, the terms of the agreement must be sufficiently certain. And fifth and lastly, there must be an exchange of what we refer to as consideration. To constitute consideration, each party must give the other something of value at a loss to itself. At the outset of an employment relationship, consideration is usually found when an employee promises to provide services to the employer, and the employer promises to provide the employee with wages and benefits in return. Therefore, a valid employment agreement creates an employment relationship before work begins. So what does it mean to rescind an offer of employment? Rescinding a job offer means to revoke, cancel, or repeal that job offer. However, in effect, when an employer rescinds an accepted offer of employment, courts have held that this constitutes either a without cause termination or a breach of contract via repudiation. So what are the consequences of an employer rescinding an accepted offer of employment? If an employment agreement is repudiated or terminated on a without cause basis, courts have held that the employee is entitled to common law pay in lieu of reasonable notice, absent an enforceable termination provision providing otherwise. Other damages might also be involved. Depending on the manner in which the employee was terminated, there could be aggravated damages, which my colleague Jennifer was discussing in her presentation, as well as other forms of damages. In any case, it's always important to remember that employees entitled to their statutory entitlements under employment labor standards legislation, because these cannot be contracted out of. So what are some key takeaways? How do we avoid the risks of rescinding an accepted offer of employment? So by way of analogy, my grandfather was a hobby carpenter, and he always used to say, measure twice, cut once. And the same applies to when you're providing a candidate with an offer of employment. Before making an offer of employment, you want to make sure that you have a high degree of certainty that no circumstances exist that might require you to rescind that offer. The second tip, sometimes unforeseen circumstances exist that require an employer to withdraw an offer of employment. And when this arises, it's important to ensure that the employee is being provided with an appropriate amount of pay in lieu of reasonable notice. If the employment agreement does not have a termination provision, then this would be common law pay in lieu of reasonable notice. And the third and last tip is to ensure that all company employment agreements contain enforceable termination provisions. That way, the employer is not liable to the employee for common law pay in lieu of reasonable notice, which can far exceed amounts that an employer can specify in an enforceable termination provision. Okay, so jumping into the second topic, the risks of two-step offers of employment. So you might be asking, what exactly is a two-step offer of employment? So a two-step offer of employment is when an employer provides a candidate with an initial, we call it a term sheet or initial offer sheet. Usually contains details concerning salary, benefits, work location, but not a lot of other details. And then sometime after providing that initial sheet, if it's acceptable to the candidate, the employer will provide a more substantive written employment agreement that contains other terms and provisions, such as termination provisions, restrictive covenants, such as non-competes and non-solicitation terms. So the problem that employers can run into with this two-step offer of employment is that this initial term sheet that's extended to the employee can constitute an enforceable employment agreement. Therefore, the second, more substantive written employment agreement that's provided to the employee can be rendered unenforceable due to a lack of fresh consideration. So how do employers avoid the risks of a two-step offer of employment process? So the first tip that employers can take to mind is to include an express term in the initial offer sheet that specifies how acceptance of the offer is to be made. So including a term in the first term sheet that says, this offer is conditional upon you reviewing and executing a written employment agreement to follow, something of that nature. The second tip is just to avoid the initial offer sheet altogether. Eliminate that first step and just provide the employee with the substantive employment agreement right off the start when the offer is extended. And a third tip is to require that the employee signs the agreement and returns the agreement to the employer before they commence work. Employers can sometimes run into another situation where the employee is provided with a written employment agreement, and then they commence their employment and sign the agreement after. And in this situation, courts have held that the agreement can sometimes be unenforceable. And as a result, there's uncertainty regarding what terms are enforceable and what terms are not. Okay, so the last topic we're going to discuss today is how to create an enforceable amendment to an accepted offer of employment. So employment agreements are not set in stone. Their terms may be amended by the parties either through express agreement or implied through their actions. So common terms that employers want to introduce into an existing employment agreement could include restrictive covenants such as non-compete, non-solicitation terms, terms concerning intellectual property or confidentiality. These terms could also be with respect to hours of work or location of work. As mentioned before on the first topic, amending an employment agreement involves 5 legal requirements, and these apply to amending employment agreements as well. With respect to consideration, when it comes to amending an employment agreement, courts are generally concerned with the existence rather than the adequacy of consideration. That means that courts are not going to undertake a weighing of the advantages and disadvantages of the employee's former agreement compared to their current agreement. However, it's advisable to exercise caution, when assessing, what consideration to use. Courts will sometimes find other ways that an employment agreement might not be unenforceable. So you might be asking yourself, okay, I understand what consideration is, but what are the different kinds of consideration that we can use, to create these enforceable employment agreements? So common types of consideration include a wage increase, a bonus, promotion, additional vacation time, increased benefits, increased termination entitlements, more favorable working arrangements. This list isn't inclusive, but those are just some of the main forms of consideration. So this concludes my update on hiring practices, as well as some tips that employers can use in the hiring process. Again, my name is Dave McDonald, and thank you for joining us today.
Thanks, David. Turning now to Dana Hooker, who's going to take us through the latest and greatest in the area of termination provisions.
Thanks, John. So I'll let that title slide come up and then we'll jump right in here. So I love this title. I can't take credit for it. This is all John. But I think this is a perfect title to discuss termination clauses, because termination clauses are so valuable as a way to limit liability for employers. But so often they can be effectively checked out by the courts if they're not drafted in an appropriate way, or as David just explained, they're not implemented. The contract in which they're contained is not implemented in an appropriate way. So John, if you don't mind flipping to the next slide, I'll jump right in here. I wanted to start this talk today with a bit of a disclaimer. So one thing that we are seeing, and I would say this is probably in the past 5 years, we're seeing a bit of divergence in the way the courts are dealing with termination clauses. For example, our friends in Ontario are seeing courts that take an increasingly intolerant view of termination clauses, where we see seemingly innocuous terms, at least from a British Columbia perspective, really become the death knell for the enforceability of clauses. And there's been a lot of constant redeveloping of these clauses. In BC, we aren't seeing the same stringent approach to the enforceability of termination clauses. Our courts, I'd say, are relatively generous and take a more broader common sense approach. But this could change. Okay, the courts are constantly reassessing the power imbalance inherent in the employment relationship, where the employer typically is considered to hold the power while the employee relatively doesn't. And this does affect how the courts perceive the contractual relationships between the parties, and it can affect how the courts and how far the courts are willing to go to enforce employer introduced termination clauses. Some of the differences are also a function of subtle variance with respect to employment standards legislation across the country, but they do exist. So today, what we're focusing on is British Columbia, and it's important to recognize that the standards and the cases that I discuss with you today may not pass muster outside of British Columbia. There are differences in Alberta, there's differences in Ontario, and then of course Quebec is a civil law jurisdiction, so this conversation doesn't really apply to Quebec. Bear that in mind, and then if you have any questions about how the principles I've discussed today might be played out in other jurisdictions outside of British Columbia, please don't hesitate to contact us and we can explain some of the nuance. So I like to think of termination clauses as an employer superpower, because despite the differences across Canada, one of the biggest consistent sources of liability for Canadian employers is this idea of reasonable notice of termination of employment under the common law, or in Quebec under the civil law. And this stems from the principle that there is, of course, no at-will employment in Canada. If an employee's employment is terminated without just cause, and just cause being a very high, difficult to attain standard, so the majority of terminations are without cause terminations in Canada, an employee will be entitled to notice of termination where just cause isn't established. And this is the majority of cases. So when you terminate an employee without cause, they're entitled to, at a minimum, their statutory notice, which in British Columbia is set out under the Employment Standards Act. In other jurisdictions, this could be statutory notice, this could be notice plus severance. It depends on the particulars of the legislation, but the statutory entitlements are the floor. And then in the absence of an enforceable termination clause, an employee has an implied right to reasonable notice of termination of employment under the common law. Now, reasonable notice is inclusive of statutory entitlements, but it is exponentially larger. It can be as much as 24 months. And to be frank, we're seeing trends where long-term employees who've spent really the majority of their working life with one employer are getting awarded more than 24 months. We're seeing awards of 26 months, 30 months in exceptional cases. Reasonable notice is not determined pursuant to a formula. The factors that a court will consider in deciding how much notice an employee is entitled to are not exhaustive. Typically, a court will look at age, length of employment, duties and responsibilities, education and experience as they relate to the availability of alternative employment, but they also look at factors such as inducement, whether service is particularly short, whether the role of the employee is particularly niche and there's a difficulty to mitigate. Sometimes they'll look at medical conditions, disabilities, whether there's extraordinary economic circumstances, and all of these will go into the pot. They'll stir it around and come out with a number. And so what happens is when common law reasonable notice is not provided to an employee, so they're not given working notice, they're terminated effective immediately, the employee will ultimately have a claim for damages in respect of their total remuneration over the notice period. So this means if you terminate someone who is entitled to 10 months of reasonable notice under the common law, they have a claim for damages for their salary, their commissions, their bonus, their incentives, their equity incentives, their benefits, their perks, their pension over the reasonable notice period. So the result of that is that employers can be faced with significant liability upon termination. And so that's why a termination clause is so important. It is the employer's ability to control those liabilities, to reduce those liabilities, and to provide some certainty to both the employer and the employee at the outset. So termination clauses allow us to avoid uncertainty and to take control. So again, common law notice is determined by the courts. Litigation, as many of you may have experienced, is inherently unpredictable. You cannot control outcomes. You cannot control what the other party will do. And ultimately, you can make your best case, but you can't with 100% certainty control what the court is going to do. Litigation is also costly, and protracted negotiations, even if you don't go to trial, there is a cost, a time, and a financial investment in negotiating a separation package with an employee who is terminated and who has an entitlement to reasonable notice. The termination clause, in contrast, brings certainty. You and the employer and the employee decide at the outset what the employee's entitlements upon termination will be. And what that means is you can avoid all of those issues and costs and time investment associated with packaging an employee out. You know, going into the relationship, how things are going to shake out when the relationship ends. But a termination clause must be enforceable. And because clauses have the ability to curtail an employee's rights upon termination significantly. So a termination clause can go so far as to say you get nothing more than your entitlements under employment standards legislation. So there's a significant curtailment of employee rights. Courts do look at these clauses carefully, and they must meet certain criteria to be enforceable. So David already talked about the 5 broad criteria that need to be satisfied in order to have an enforceable agreement. With respect to termination clauses, what we see as being the biggest issues is, number 1, is the clause supported by consideration? So has the employee signed the employment agreement before, not on, not after their first day of work, okay? If you have a 2-step offer process, does that first step include reference to the need to sign an employment agreement, and employment being conditional on that, as David discussed? So is there consideration? If you're changing a role, if you are introducing a new contract, have you provided fresh consideration? Have you given the employee a signing bonus? Are they getting a raise? Is that consideration being provided conditionally on the employee signing the new agreement? So do you have the one of the key elements of an enforceable contract? Additionally, also as David mentioned in his presentation, the terms need to be sufficiently certain. So is the termination clause clear and unambiguous? Does the clause clearly limit or eliminate an employee's entitlement to reasonable notice? And so precision in drafting is very important. Avoid gobbledygook. Keep it clear, keep it simple, and keep it concise. Is the clause compliant with applicable employment standards legislation? So it has to be lawful, and it's consistent across Canada that you cannot contract out of the minimum standards under employment standards legislation, and any attempt to do so is void. So if you have a termination clause that says the employee will get less than their entitlements under, in BC, the Employment Standards Act, that clause is not going to be enforceable. It's going to be thrown out, and the employee is going to have an entitlement to reasonable notice. So it's extremely important that your clause is drafted in such a way that the employee does not receive less than their statutory entitlements. So what's the BC approach? So I alluded at the beginning of this presentation to there being some divergence, and there is, and I think the starkest examples of this divergence are probably Ontario versus British Columbia. So what's the BC approach? I'm happy to report that in BC, the approach is pretty common sense driven. And this summer, our Court of Appeal released a decision that really solidified that. We always knew that our courts were going to be a little bit more generous, but there was still some uncertainty or tension regarding how explicit a clause had to be. And there is debate and there is divergence across the country. And to date, to this summer, there was some debate in British Columbia about how precisely the language needed to override the employee's implied right to common law notice, how precise that language had to be. And we would often see cases in BC where we would want the employer to say, you will receive only your entitlements under employment standards legislation or something to that effect. It had to have that only or that limiting language. But in the case of Egan and Harbour Air, the Court of Appeal said, actually, you don't need to be that explicit in a termination clause. It is sufficient to simply incorporate referentially employment standards minimums to oust the employee's implied right to reasonable notice of termination under the common law. So in Evans, the clause in question said the employer may terminate the employee's employment at any time without cause, so long as it provides appropriate notice and severance in accordance with the requirements of the Canada Labour Code. So in this case, Harbour Air, being an airline, was federally regulated, but that could have just as easily said the British Columbia Employment Standards Act. And the first question the court had to address is this a floor? So are we saying this is the minimum you'll get? Is this really just a restatement of the employee's statutory entitlements? Or is it in fact a ceiling? Does this clause preclude the employee's claims for reasonable notice under the common law? And the court erred on the side of ceiling. And really what it said is, look, we need to approach this with common sense. We can't be taking these clauses apart word by word by word, looking for something that, you know, is our aha moment and saying, no, this cannot be enforceable. That's not how you interpret a contract. Okay, you interpret a contract by looking at the contract as a whole and consistent with the surrounding circumstances at the time the parties entered into that contract. Okay, and on the whole, the court decided that this language that we see here was sufficient. It wasn't merely a restatement of the floor. It was in fact a ceiling. It was exhaustive of the employee's entitlements. The other issue that came up in Egan is whether this clause actually complied with the Canada Labour Code. Now, the Canada Labour Code provides for notice, pay in lieu thereof, and statutory severance. And the employee argued that because this clause didn't refer to the employee's total remuneration package, so his salary, his bonus, his benefits, this was an impermissible contracting out of the Canada Labour Code, which, when it refers to pay in lieu of notice, talks about the employee's total wages. And that's similar to how it's addressed in British Columbia and I believe in a number of other Canadian provinces as well. And so the employee argued that by not actually expressly addressing the issue of the individual elements of the employee's package and what had to be continued during the statutory notice period under the code, the court said, no, you're not contracting out of the act, or you're not engaging in an impermissible contracting out of the act by virtue of silence. We'll take the position that this referential incorporation of the terms of the code into the contract is sufficient. There's nothing in here that suggests that the employer wouldn't comply with the terms and requirements of the Canada Labour Code. So we're not going to say this isn't permissible. Now, had the employer said you're only going to get base salary, that might have been an issue, right? Because wages under the code constitute more than just base salary, right? They can include incentives, they can include other forms of compensation as well. But because the employer was silent here, the court said, no, this is fine. This is not an impermissible contracting out of the code, and it doesn't, the employee is not successful on this point. So ultimately, this very simple, very short termination provision was enough to limit the employee's entitlements to reasonable notice under the common law, and the employer therefore had their liability significantly limited to only, at that time, notice was 2 weeks, and the employee's severance entitlement was only 5 days. Had the employee had a common law notice entitlement, the employer's exposure would have been much more significant. So the message here is that BC says the common sense approach reigns. However, you still need to be careful. You still need to be precise. We would still recommend typically additional language that says very clearly, this is everything you're going to get, and you have absolutely no entitlement to any other damages, notice, severance whatsoever. But nevertheless, in British Columbia, we don't need to nitpick, I would say. And it is enough, based on this case, to referentially incorporate the provisions of applicable employment and labor standards legislation, and you don't need to have more. As a final comment before I close today, because of the importance of these clauses, because they are the superpower, please reach out to us to assist. We can vet, we can draft, we can make sure that in the constantly changing environment, the clause is going to be okay. And of course, don't assume that because the clause is okay and we've signed off in BC, that you're going to be okay in Alberta, Ontario, Quebec, Nova Scotia. You need to ensure that your clause meets the requirements in each province to protect yourself as an employer from the liabilities associated with a without cause termination of employment.
Thanks, Dan. I think I've tried not to chime in after every presentation because there's so many neat things, but that certainty piece is so important. It's one of the only winners in uncertainty are the lawyers. And so it's one of the ways that you can frame it for individuals to make it a win-win. These things are so contentious.
Yes.
Okay, I'll pass the proverbial mic over to Struan Robertson, who is going to take us through some developments in workplace investigations because human resources professionals don't have enough responsibility already.
Thanks, John. I agree, let's just pile on a few more tasks onto their already busy plate. So as John alluded to, I'm going to be talking about investigations, which is kind of a critical piece and becoming more and more important for employers to understand in the ever-changing world of statutory requirements and the evolution of the common law. So let's begin. So who investigates and what is investigated? So there's a constant question we face is, okay, well, if we're faced with a situation where we need to investigate something, do we do it internally or do we do it externally? Our recommendation is typically, let's first figure out what exactly it is that's being investigated and how serious is the conduct. If we see it in many respects, we need to look at it like a scale or a spectrum of the seriousness of the issue, with kind of, trivial inner workplace issues being on one end and really serious issues like fatalities or serious complaints of sexual assault and things like that on the other end. So it's really just going to depend on the seriousness of the issue before we determine whether an internal investigator is appropriate or an external. The benefits oftentimes of appointing an external investigator is you have a better chance of maintaining privilege over that investigation. I say a better chance because it is not an absolute right that you will be able to maintain privilege over the investigation file. In a recent decision from the Alberta courts, an investigator was appointed, a third-party HR consultant was appointed, and it related to a wrongful dismissal or an allegation of wrongful dismissal, and plaintiff's counsel was seeking the investigation file of the third-party investigator, who was not actually a lawyer in the circumstances, but was retained by the employer. And what they did is the plaintiff's counsel tried to seek actually basically the notes, transcripts, and factual findings of the investigation, and most notably not the actual report that was produced by this third-party consultant. And what the court said was, yeah, those facts are not subject to the privilege. And they're not subject to litigation privilege because those facts are actually discoverable. You can't claim privilege over facts. But what you can claim privilege over is a work product that is created as a result of investigating a matter in order to seek legal advice. So the investigation, the report itself would be privileged. Another interesting point here is that in the pleading in the case, the defense, the employer pled and relied upon the investigation report to support its decision its termination decision. And therefore, even if the judge said, even if I'm wrong about my privilege analysis, I find that they've waived their privilege by expressly relying upon the investigation. Investigations and maintaining privilege is a very technical, and we need to be very careful. We oftentimes, a strategy we employ is the law firm will actually engage the third-party investigator. And if it is a more serious issue, we have recommended counsel that we use for investigations who are very capable and in that kind of field. And what we'll do is we'll engage them directly and create a buffer between the employer and the investigator in the hopes that might protect the privilege. So where and when does an investigation unfold? As you might appreciate with the work from home approach, there's a great deal of investigations that are driven by the virtual world. And that might include a forensic analysis of computers, traffic on the computer, things like that. There's a lot of information, as I'm sure comes as no shock, that might be revealed from an analysis of people's servers and things like that. So at the first point of contact of determining, okay, what are we investigating? That the next point is, okay, where is the information that we need? Is it all exclusively virtual, or is it a more of an old school approach of just interviewing witnesses? The other part is timing is critical. We don't want investigations to lag. Unfortunately, people's memories fade. And so the closer we can begin the investigation process to the actual incident, the better. We also need to consider, okay, are we satisfying a statutory requirement? In BC, there's requirements under the applicable occupational health and safety legislation that requires employers to investigate fatalities and serious injury issues, bullying and harassment, things like that. So that's really something that we need to always consider is this a statutory requirement or is this an internal policy? Because that will change the nature of how we go about the investigation. Also, something that we're always asked is, do we need to investigate former employees? Some case law suggests that there is no obligation to investigate former employees. And again, you need to go back to the first question is, okay, well, what is the seriousness of the issue involved? And is it something that, notwithstanding an employee has left, that we want to investigate in any event to ensure that down the road, no one's coming back to us and suggesting, well, this was a really serious issue. Why didn't you investigate it? It doesn't matter that the employee left. The next point is interesting because in a relatively recent decision, which kind of reaffirmed our understanding of the law, is that there is no duty of procedural fairness when the employment relationship is exclusively governed by contract. And that's an important piece to note, because in this decision, there were some allegations that the investigation was a complete sham. But notwithstanding that, the judge said, well, that's not actually relevant because there is no obligation of procedural fairness. So even with those kind of comments, we implore employers to conduct really good investigations, because the last thing you want is a recorded decision saying that the investigation was a sham and suffer some reputational harm there too. Recently, the Supreme Court of Canada has actually said that, and the facts of this case are somewhat interesting. There was a couple of teachers who were maintaining a log of complaints, and the principal had heard about this log and basically went into their teaching room, looked on the computer, found the logs, and then there was a disciplinary letter sent to these teachers. And there was a grievance, obviously unionized environment, and then there was a decision by the arbitrator that the charter did not apply to these teachers, and the Supreme Court of Canada clarified that no, actually, because this is a government entity, the teachers have the protections of the charter, which is to secure against an unlawful search and seizure. And so quite a notable change. The law wasn't, people hadn't really challenged the notion that charters applied to schools in Ontario, but this was a real clarification of that point. And the Supreme Court of Canada said, well, and this only applies to the schools in Ontario, but it could We haven't yet decided whether it would apply to schools in other provinces and also private schools, which was notable. So the question is, why do we investigate? I mean, there's a host of reasons why we always recommend investigating serious issues. The first is that it's a fact gathering and evaluating risk by someone objective coming into the situation, which is always helpful. Second, there's potential statutory requirements where you need to satisfy those. Third, managing potential liabilities. It's good to know at the outset whether there is exposure here for the employer and whether it's something we need to be aware of. Fourth, remediating misconduct. Where there has been an adverse finding against an individual employee, we can then try to remediate that misconduct. And last is more of a fairly broad kind of term, but to create a culture of transparency. Some employers employ this to make sure that the issues are investigated and those findings come to light. Obviously, there's a time and a place for this when we don't want to maintain privilege. So that is 101 on investigations as it stands. Happy to answer questions if anyone has them. Thanks, John.
Thanks, Struan. Maybe there were a lot of questions, and so we won't be able to get to everyone's questions, but please don't hesitate to reach out after today's presentation. But maybe just to really quickly get some of the questions of particular interest. One question came in for Jen regarding what if an employer provides no reason at the time of termination, and this is of course arising in the context of aggravated damages, damages outside of the notice period, strictly speaking.
Yeah, so technically under the Ontario Employment Standards Act, an employer isn't required to provide reasons, but the problem with not providing reasons is that the employee gets to kind of fill in the dots. So if we think back to Krumpotek, that case, he was terminated 2 hours after he returns from a medical leave of absence to get a back surgery. So if an employer doesn't say financial reasons, the obvious next guess is a discriminatory reasons based on his physical disability, right? So it often is good to provide reasons so that you can justify at the outset what your principle was for terminating the employee. It's just also important to have that background. So say if it's performance reasons, you just want to say that so that you're not, coming from behind after you've terminated the employee and then they get counsel and make up their own reasons.
Thanks, Jen. One other question that came in was for Dana. Regarding the interaction between consideration and notice. For example, if an employer has provided sufficient common law notice of a change to an employment term, are they still obligated to provide fresh consideration?
Yeah, so here's the concern that I see when we talk about providing notice of a change in lieu of consideration. If you are wanting to impose something like a termination clause, a restrictive covenant, some sort of protection of corporate interests, implementing that and relying on reasonable notice to get it through is very risky, because in the absence of a termination clause at the outset, the question is always, well, what is an appropriate amount of reasonable notice? And also, if you're dealing with long-term employees, it could be 15 months, it could be 24 months. And are you actually going to wait that long before you implement your contractual change? When you're dealing with changes that are less critical to the organization, I would say, and particularly where you have a termination clause that says in the event of termination, you're going to get, for example, ESA minimums plus a week, then you can maybe implement that change relying on that notice period. Because the whole idea of providing reasonable notice to get a contract over the finish line is to avoid claims of constructive dismissal. Because when an employee says, okay, you employer unilaterally made a change to my contract, I'm going to say that's tantamount to a termination. Therefore, I'm entitled to notice. If you provide them reasonable notice of the change before it's implemented, it really minimizes their damages. But when we're talking about implementing key contractual terms, my advice and my practice is to say, give that fresh consideration. Even you give fresh consideration and notice, because, you know, as David mentioned, the courts don't require a certain amount of consideration. I mean, it can, in theory, be a mere peppercorn. Now, we always recommend, because of some of the other factors that the courts will consider, including the power imbalance between employer, and employee, that there be some meat to the consideration that's given, but it doesn't have to be huge. Sometimes a, you know, fairly modest signing bonus, all things considered, is enough. And, you know, I would say that if you're really concerned about the terms you're implementing, go the consideration route. If there are more minor adjustments or changes, maybe it's a change to the way vacation rolls over, for example, you could try going the reasonable notice approach. But it's really going to be very context specific as to when it's used.
That's great, Dan. I think it's a really practical way to distill what is very technical and lots of intersections there. Maybe time for just one more, one question for Aaron. What if an employer is reasonably sure that an employee is unaware of their disability, for example, autism, and believes that inquiring would cause the employee stress? Can the employer simply do their best to accommodate without inquiring if it feels it can do so appropriately?
Yeah, so great question. And it is going to be context dependent, but one important thing to keep in mind is to ensure that we're not diagnosing the disability ourselves, as that could lead to issues. But generally speaking, we want to keep responding to any issues or behaviors that come up on a case-by-case basis, and it's really going to depend on what the objectives are in each of those cases. If there's issues that need to be addressed and are causing disruption, and the employee is showing signs of volatility, again, it's going to be a delicate way to approach that conversation or those conversations, and we'd be certainly happy to assist. But generally speaking, we want to offer support, raise the issues, and there's a variety of ways that you can inquire into a disability in a way that can hopefully alleviate some of those circumstances. So yeah, oftentimes clients say, Aaron, I can't manage my workforce anymore, and there's concerns with that. And just things we remind clients is, while it can be administratively intensive at the outset, the opposite, if things escalate after termination or if things move quickly, it's very easy to get drug into, at least in my practice in British Columbia and Alberta, 2 to 3 year process defending against a human rights complaint. Much more time intensive, much more expensive. And so we always preach the gospel that an ounce of prevention is worth, or ounce of prevention is worth a pound of cure. So again, if you have any further questions on that, we'd be happy to reach out and speak to the specific facts that you're dealing with. Thanks.
You took the words right out of my mouth. An ounce of prevention is worth a pound of cure. This one in particular. So thank you very much, everyone. We hope you enjoyed our presentation. It's our privilege to get to do these sorts of webinars with you all, and looking forward to chatting with some of you soon, I'm sure, on some of these issues. Thanks very much. Take care.